Welcome to the Future Media Podcast. I'm Ricky Sutton.
And I'm Alan Chappell, and this podcast goes deep into the practices of big tech
and the future of the world.
We explore how companies like Google, Meta, and Apple are impacting each of our lives.
I'm an investigative reporter.
And I'm a privacy lawyer.
And every week we speak with experts to bring the unreported details into the light. One law has done more than most to create an anti-competitive playing field that's left the world's publishers with all of the costs and none of the benefits of publishing the truth. I've been an undercover reporter for 30 years, so I know how important it is to get to the facts and how hard it can be. I also know how costly it can be if you get it wrong. That said, being sued is part of the job. It's part of being accountable. After all, the really big stories are the ones that someone wealthy or powerful, and more commonly both, doesn't want revealed. But that's a price that all journalists worth their salt are willing to pay. But reporting and journalism are not the same thing, and it's important to know that in this era. Reporting is just telling the news, things that have happened, and algorithms can do that. Google can do that. Google tends to do more of that, or intends to do more of that with AI overviews as we go forward, and that's going to disintermediate the news industry even further. But journalism is fundamentally different. Journalism exists to tell you the why and explain what it means, and it often involves breaking stories that no one else in the world knows, and that informs the world in a different way. And AI and tech platforms just can't do that. That's journalists' job. And getting to the facts and delivering that critical public service makes the risks worth it. Let me give you some personal examples because I think it's much easier to ground this stuff if you understand it, having heard it from somebody that's been there. So a few years ago, while undercover exposing an international paedophile ring in Cuba, I was arrested for spying and jailed for 8 years. And I was told that I would be targeted in jail, assaulted and left scarred for life. And as I waited in a holding cell, the Cuban government lost its nerve and deported me at gunpoint instead. That expose, that story that I wrote, that I investigated and that I found, stopped a wealthy international pop star paedophile from preying on girls in a country where their impoverished parents knew what was happening, but they were incapable of protecting them. It was worth it. And then a few years later, I spent a terrifying year defending myself against a sex cult which threw tens of millions of dollars at a spurious case with the sole intention of bankrupting me. Again, my story ran, and the court case was thrown out, and thousands of vulnerable people looking for love, who were being coerced to hand over their life savings, were protected. Again, it was worth it. Both of those stories then made headlines. Things changed, and the stories behind those stories are now both Netflix documentaries. Today, journalists still face all of those hurdles, but in recent years, they've been given a new one. And this one's much more insidious, and it's designed to take power from the truth, which is what I care about, and give it back to the powerful to silence it. It's one that's become entirely counterproductive, in my view, to creating a better world, and which may, now, finally, be overturned. It's called Section 230. You'll probably have never heard about it, but that's what Alan and I are going to be talking about. And it takes us back to the early 90s. Alan, you're a lawyer. Let's remember what that period was about.
Well, yeah, and maybe we start with what was going on at that period. Now, for me personally, I was still a touring musician going around to different parts of the U.S. I hadn't quite made my way to India. I think that was a few years later. But what I can remember is a couple of things. We at that point had maybe 50 cable channels. Even 5-7 years before that, we might have had 25. So the diversity of content choices had exploded, but nonetheless, they were significantly smaller than what we have today that we sort of now, I think, take for granted to a certain extent. So it's the early 90s, the ability to impact, culture was limited to a relatively small group of tastemakers as compared to today. You were in Bosnia at that time covering a war. I can remember that we had, I think, one cable station that might have touched on that a little bit, other than the 2.5 minutes you get on that on the daily news. And so today you now have a whole bunch of different options, not just via cable TV, but you have options via the internet, and you've got even some social platforms who are at least providing a perspective. Now, they may not be a journalism perspective, but they are providing a perspective. So 1992, 93, we were just beginning the commercial internet. I can remember CompuServe was one of the first online services, and at the time, they were basically a bulletin board. They were, it provided their users with the capability to share a little bit of content, to post things that they thought were sort of interesting. Now, ultimately, CompuServe ended up getting sued because sooner or later somebody had posted something that tripped either, that he either tripped a defamation claim or at least had ticked somebody off. And ultimately, CompuServe was able to prevail in part because they made the claim, look, we are more analogous to a bookseller or a newsstand. We aren't really doing anything with it. All we're doing is posting this content. Fast forward maybe a year, and you've got Prodigy, which is a similar online service with one key distinction. Prodigy was touted as sort of the family-friendly online service. They had specifically curated their offerings and sort of been held themselves out as like, we're going to give you a family-safe internet experience. Now, ultimately, Prodigy also got sued because somebody had posted some allegedly problematic content regarding a person named Jordan Belfort, who many here probably don't know, but they might be familiar with the Wolf of Wall Street, the movie. So he ran a boiler room, which was sort of the groups of people who way back in the day used to call you up at home and say, hey, would you like to buy a stock? This is long before the commercial internet. But anyway, Prodigy ultimately lost. And the reason that they lost in part was, well, there wasn't a whole lot of precedent here. Judges were just getting their heads around what an online service was. But also the fact that they had held themselves out as curating was sort of the thing that ultimately did them in here. And ultimately, Prodigy lost that case. However, there's a number of people in the U.S. Congress, most notably Representative Cox and Senator Wyden, who said, well, wait a minute, we see what's going on here, and we don't think that setting up a restrictive set of rules or creating an unlimited liability will enable the online services to grow and develop like they hoped. I don't think they were Nostradamus here, but I do think they realized there was something to this. And so they passed Section 230 of the Communications Decency Act in 1996, I think, and it actually applied retroactively, so it addressed the specific issue that Prodigy was suffering from.
I wonder if people realize just how important a law that would later become, because you can see the logic of what they're trying to do. The idea is, as much as a critic as I am today of 230, you can really see what was trying to be achieved. I think the entire world had newspapers and TV, as you describe, for the best part of 100 years in print's case, and it wasn't really adapting to the new world environment. And there was so much to cover. You mentioned I was covering the war, and so you want to get your story to as many people in as many different places as you can. And we knew that technology was moving very, very quickly. And so, I wasn't really aware of the internet at that time, or that it was coming. I was really just focused on the stories. But I've always been an early technology adopter. So as soon as something new like that would have emerged, I would have been on it in a heartbeat. But I can tell you this, that we're jumping around a little bit in the history books here. But what I can tell you is that when I did become aware of the internet, my immediate reaction was that this is going to create a whole new kind of digital democracy of opportunity. Everybody everywhere is going to be able to access all the world's information, which means that everyone is being schooled effectively. Even poor people and poor kids in Africa are going to be able to get a chance to rise up. And so I actually love the concept of 230. I'm just not sure it's gone the way we wanted it to go.
Yeah, I don't think you can undersell the cultural component here. So, my 20-ish-year-old self was thinking, man, how do I get my music out to more people? And boy, how frustrated am I at these record companies or radio stations who seem to be in cahoots and were preventing the world from hearing my brilliant, brilliant music. Now, that's probably a debatable point, but you kind of get the sentiment, the idea that there were a number of gatekeepers that were preventing those of us who really wanted to share our art with the broader world. And so we saw them as being in the way, and we wanted to disintermediate them. Now, I was not, running an online service back in 1992, 1993, but I was certainly part of that culture and ultimately ended up at a company called Jupiter Research just a couple of years later, and where that really continued. There was a cultural movement around getting rid of the old gatekeepers, and that's, I think, what's driving or what drove Section 230 in the first place.
So in 1996, when Section 230 becomes a law, okay, I am just transitioning to join the largest newspaper in the world. And my stories are going to reach 40, 50 million people a day. And, it's a very exciting time for me. But then on the other side of the world is this piece of legislation being passed that I knew absolutely nothing about. So I'm just going to tell you, I'm just going to read, I know you know, Alan, but I'm just going to read for the listeners what Section 230 actually says. Section 230C, Part 1, provides immunity from liability for providers and users of an interactive computer service who publish information provided by third-party users. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So my shorthand of this, Alan, you're a lawyer, so you can offer a better one. My shorthand of this is, you as a platform, you're not responsible for what you publish, okay? In the same way as you're not responsible for what somebody might say down a telephone if you're the telephone company. But it basically means that you can grow, and the person that says the thing that you publish, you are liable for. Yeah? Or they are liable for. Have I got that right?
I think you've got it right, but there's one additional component which is sort of important. It's not just the website or online service that is shielded from liability. It's anybody using that online service that shares the potentially offending content. So the protection there was not just for the platforms, the protection was there for the users of the platforms as well, as long as they were not the originators of the content.
Right. So again, I'm a firm believer in maneuvering and changing and adapting and evolving the way that news and information is distributed. All information is distributed. I'm an early technology adopter. Even in '96, I think I broke a story using internet relay chat. Okay, back in the day when no one else knew what it was. I spent $10,000 on my first laptop. It was about the size of a house brick, and no one could believe that I was doing this. So I'm always a firm believer. I was also the first head of digital for News Corp in the UK. And so I really, really wanted this internet to evolve. But I came from a perspective of having run large newsrooms and large media companies previously. And I knew that if I wrote something that was wrong, I was going to get in terrible trouble for that. Even if somebody else had told me something and then I wrote it, I was liable. Even if I allowed someone else to write in my newspaper under their own name and publish it, I was still liable, which is a very different distinction from what 230 gave to the web. Yeah. And so it kind of created a double standard. And I think my first sense of nervousness around it came in the very, very early 2000s. So we had this incredible situation in 2000 that we had 19 or 20 million readers of our website. They were all over the world. We'd always been a UK newspaper at that point, but suddenly we had this global reach. But what was most fascinating of all was that we would write a story. Thousands and thousands of people would come in and comment on the story. Yeah. And I was so proud of this flourishing conversation we had with our audience, who previously we'd never had a one-to-one relationship with. I loved it. Our lawyers hated it because what they saw was a massive new liability. And so they were saying to me, Ricky, how are you going to moderate these 18,960 comments on this article? Yeah. And I was like, well, we should hire moderators because we have to have a conversation with our audience, right? That's the right thing to do. And our lawyers were absolutely not. You'll miss something. Shut it down. And I remember distinctly my reaction was, so we don't want to talk to our audience? Is that what we're saying? Because that feels troublesome to me. And so to try and figure out what protections we had in place, in 2001, I went and read up on Section 230 and started to think about, well, maybe we can use Section 230 in some way. I went back to our lawyers, showed it to them. They scoffed, laughed it off, and told us it would never happen. And so as a result, we shut off conversations with our readers. And that left a gaping void for others, like Facebook that came along in 2004 and others, to fill the gap. And so 230 probably could have worked for the news industry if they'd adopted it early. Actually, let me ask you, do you think the news industry could have adopted it, or do you think that it was just too distinct?
No, I think absolutely. I mean, I think that on some level, conservative lawyers within the news industry ceded the number one thing culturally about the news industry. That thing is you stopped being the town square upon which everybody gathered and shared common knowledge. There was once upon a time, there were piazzas that still exist in Italy where, newspapers, people would be reading them and somebody would come over to the coffee shop and say, hey, yeah, you saw how the local sports team, boy, those guys really screwed up. And that was the culture. And for a whole bunch of reasons, a lot of that discourse has moved online. And for whatever reason, the news industry has chosen not to participate in that. My view, that was a mistake. Now, it's very easy to look back at a decision that was made 25 years ago and say, well, that was probably a mistake. But you did sort of cede the conversation to somebody else. Initially, it was probably AOL, but then eventually it was, Friendster, MySpace, and then Facebook.
Yeah, and Yahoo. Yeah. So I remember them all coming to see us and saying, how can we work with you on these conversations? And our lawyers were like, terrific, take them. And I was like, I'm not sure about that. I actually wrote a business case for a social media network that was called MyX, which was pitched to News Corp around the same time as Facebook launched. And I would love to have seen what the difference between, Facebook's early investors and I know what my legal team's reaction was. It was just like, absolutely, definitely, never, ever going to happen, right? And of course, then News Corp bought MySpace, and I was on the board of MySpace for a couple of board meetings and watched, how we then took a company that tried to do this in reaction as a defensive move and then killed it. So many opportunities were missed, but the problem that it's kind of created is that the tech companies have been able to use 230 as an accelerant in an astonishing way, to grow to a massive scale. And because they've more than adopted it, it's been baked into their DNA and their growth strategy. Whereas on the news industry side, we've been left with all of the responsibility to ensure that what we publish is correct, all of the costs of hiring the journalists, all of the risks for those journalists that are out there doing the dangerous work, and none of the scale, and none of the advertising revenue, and none of the halo effect. And so the business that's trying to tell the truth but can't scale has all the costs and none of the benefit. And the organizations, in my opinion, in the big tech side, who have been given or have adopted this law to have all the opportunity and all the scale, have taken all the money. And, really for the last 10 years, I've been trying to bring those two parties together so we can have truth at scale that's financially viable, rather than just untruth or truth that doesn't make money.
Yeah, that makes sense. So one thing that I think is going to be a theme in our conversation here today is, what is who's the villain in this? Is the villain Section 230, or is the villain that the fact that these companies have become way too big and it's just impossible absent some pretty significant changes in how we view antitrust law, at least in the U.S., without breaking them down. So what's the villain here?
Yeah, so I'm going to answer that slightly differently. I'm going to answer it, but I think the first thing to think about is, who are we doing this work for, right? Well, what is the common integral for both the media and the tech industries? At the end of the day, our job is to satisfy, engage, delight, entertain the consumer. That's what we're for. Otherwise, what is the point of having tech? What is the point of having media? All right. And so we have to put the consumer at the center of all of our decisions. What I think has happened is that the tech industry has figured out that the best way to make the most money is to throw incredible amounts of content, right, wrong, true, false, at the consumer and sell as many ads as possible. That's what the tech industry has done. And the news industry has doubled down on content being king and really focused on producing content that it really thinks is important for the world, that reaches less people and engages less people and makes less money. Now, both of those things have their merits, but the real sweet spot is if those two things can work together. Okay. So Section 230, in its reason, the reason it exists isn't inherently bad. What's bad is what people do with it. And so I've very much viewed that the world is on two tracks. The journalism industry is shrinking by trying to do the right thing. The tech industry is expanding by not really caring whether it's doing the right thing or not. And the commercial and the social imperatives of those two things ultimately mean the consumer is getting a worse deal every day. Okay. And so that's how I feel. And really, the way I try and describe that complex thing when I'm on stage is that we have two industries. One speaks fluent French, the other speaks fluent Swahili. They're talking about the same thing, but they can't talk to each other. And what we need to do is to get these two industries to merge somewhere in the middle, where we can create great journalism at scale that's monetizable. That benefits the tech companies and the media companies, which I appreciate after 25 years of heading in different directions is difficult to bring back onto the same track. But that's really what we have to do if we want the consumer to be happy.
Yeah, it sounds great. Getting that done is certainly a little bit more challenging, but I do think that the publishing industry in general needs to be more like the tech giants. There's I think a cultural resistance to that seems to exist to this day.
Yeah, do you know what though? It's March the 30th, 2025. There's been some time for the news industry to figure this out. Okay, it's not like this happened yesterday. And I think that we are at a transition point where the news industry is probably on its last legs. Okay, so, I think something like more than half of all the world's journalists have been fired in the last decade, which means that less of the world's information is being reported. And the world feels less safe to me, not more safe. Okay, and so that has to be a net negative for consumers. I think that politicians and governments have figured out that a world without independent journalism isn't a great outcome. So maybe laws that are perhaps unfair to them might need some kind of repeal or reconsideration. I think the tech companies, $13.5 trillion in value and rising and wanting to adapt to AI, also probably appreciate internally quietly that they might need some guardrails to help them point themselves north. And I think the rich have got richer and everyone else has got considerably poorer. And so everything that says change should happen is now in place. And so I would hope that the news leadership either, and I'm pretty tough with them face to face. I don't only say this behind a microphone. I'll say this to them all the time, is that we've probably got the wrong leadership for this phase of the future of the media industry. News reporting and journalism has been perpetual and will continue to happen in some format or other. But if the companies that exist today don't adapt now, there won't be a tomorrow for them. There'll be a tomorrow for whatever replaces them. And so I really think that this is a moment, a review of 230 is due, and an appreciation of the media leadership that they're the wrong people for the next era also needs to happen. If those two things can happen, then you can close the gap between those two industries.
So do we want to talk a bit about why Section 230 is under attack? I mean, you've made a very convincing argument here, purely from the perspective of publishers. But I think it's probably broader than just that. And maybe it would be interesting for us to sort of talk a little bit about what levers there are. So the first is that, there is clearly over the last, 5 to 10 years, there's what you could call a techlash. There is a loss of trust in the tech platforms, both from a perspective of users and from the perspective of, politicians and policymakers. And some of that is driven by the fact that on some level, Section 30 has failed to meet a number of its stated goals. I mean, the goal for Section 230 was, first, how do we encourage moderation? How do we encourage reasonable levels of moderation so that companies can feel like we can keep a level playing field where really bad stuff doesn't happen? And if anything, content moderation seems to be in decline across some of the larger platforms. The second thing is that, the Section 230 provides a liability shield, which enables smaller companies to grow, which is great. And there are certainly examples of smaller companies who would benefit from that. But the net here is that we have still had a media consolidation in the tech space where there's 5 to 7 very, very large companies who are basically controlling everything in the world at this point.
You raise a fascinating point there that I hadn't really considered before, is that Section 230 was created to enable the underlings to scale. All right. And now it's the heat shield for the companies that are the largest 5 companies on the planet. And that means that there is very little opportunity for new small companies to emerge, which is what 230 was intended to be, right? To create a new industry. That industry exists. Perhaps when we reach a situation, and you tell me what you think, but when monopoly meets 230, okay, that is a very different outcome. And, that's kind of what's happening right now, right?
Oh, absolutely. And that gets to my earlier point that really, again, the villain here might just be large companies that need to be broken up, perhaps even more so than to Section 230. But I want to get to the third, which is, one of the goals was to encourage a diversity of opinions to be widely available and not stuck behind a paywall. Now, the problem with that is that what we're seeing more and more is that quality content, we can debate the definition of quality, but I think most people kind of know it when they see it. I mean, something that qualifies as journalism. Something that's quality is increasingly being put behind a paywall. And so if you think about, okay, well, encourage moderation, liability shield, and diversity of opinion, not behind a paywall. And it's like, well, great, but all those things are still happening. So, there's certainly the mind goes to, well, what do we need Section 230 for if it's failing to meet its core objectives?
Yeah, I'd go further, Alan. I don't think that that's not happening. I think the opposite is accelerating. I think it's actually now causing the opposite. And so, the reason that newspapers and media brands are putting their content behind a paywall is because they can no longer access the advertising that used to pay 80% of their costs. And that's because the big tech companies take all the advertising and all the growth of advertising. Okay. And so publishers don't inherently want to put their content behind a paywall. They're not putting it behind a paywall because they are supremely confident in how fantastic they are, and you should absolutely have to pay for our fantastic work. They're putting it behind a paywall because they can't afford to keep the coffee machine on.
I agree with all of that. But is that really a Section 230 issue, or is that a companies are too big issue?
Yeah, 100%. But the argument from the publisher side, and actually let's forget about pushing it to them. My argument, my personal argument, is that the Section 230 protections of liability, okay, have enabled them to publish anything they want at scale. And we know that anger and hate are motivators for engagement that can then be sold. And those are things that normal publishers can't do and wouldn't do anyway, frankly. And so the challenge then is that if every single dollar in the world flows to the people who are most animated, it flows directly to those platforms, and those platforms can publish that content with immunity because of 230. And so those things are all interconnected.
I think that's a fair way of looking at it. So uh, I just wanted to close the loop on some of the reasons why Section 230 is under attack, and the last two are really more political issues, and you could say that maybe they're two of the more important ones. But what's driving Section 230 reform in the U.S., or a large part of it, is the fear that these platforms are silencing conservative voices. Now, I think you have to put that into the context where it sits. So, that's the same mindset for the last decade and a half has said that there's a deliberate war on Christmas within the US. I don't know that it's so much that they're silencing conservative voices. I think that historically they've tried to silence voices who were orchestrating an uprising on the U.S. Congress, or something of that ilk, or just out and out lying. That the platforms were I think for a time trying to moderate their platforms to address those types of things. And then the last reason is that there's sort of a sense that the market will ultimately address some of the lack of moderation issues. And this is one I have a little trouble with because I just don't see it happening. The idea that advertisers are going to step in and say, okay, Meta, we don't like the way that you are moderating, and we are now uncomfortable. We feel like your platform is no longer safe for our brands. And the reason I have a challenge with that is that happens in spurts for a very short periods of time. And then when no one's looking, it turns out that the advertisers come back, and they don't always come back in response to changes to the platform rules. I mean, heck, the number of advertisers who've come back to X over the last 3 months is quite noteworthy, given and even then, the reason a lot of them left had much less to do with their moderation policies, which were at best peculiar. It wasn't even about that. It was about Elon Musk telling advertisers in a room that they should go F themselves. And so that was a lot of the thing that they were responding to. So I'm skeptical that there's a market solution for this. And I think that a lot of the Section 230 proponents lean in on the idea that the market is going to take care of that. And I just don't think that's a long-term solution.
Oh, I think the data would certainly back you up in that. So let's break down those two things. The first one, we'll come back to political bias. But first of all, let's talk about the commercials. So Meta is probably under more pressure now than it's ever been, and it's a fortnight away from an antitrust breakup trial. Grew its revenue 22% last year to $164.5 billion, and was the fastest growing of the tech stocks over the course of the year, despite on paper having the worst year ever. And then if you look at Google, Google's probably also had its worst year ever because of AI Overviews, its new AI search product, which doesn't work. And it grew, 14% to $350 billion. And if you take the publishing industry, across all of the 3,600 major or largest publishers across the entire world, overall traffic referrals from Google and Meta were down 40%. Meta has banned news content altogether on its platform in Canada and is in the process of doing the same thing in Australia. And just last week, Google turned off all news content from 11,000 publishers across 11 European countries to see whether people really cared or not. So there's only one winner that can ever emerge from the market economics of the structure we're in today. So 230 is not completely to blame for that, but it is probably one of the two major reasons. With regards to the political debate, now that's an almost uniquely American perspective, an American problem. So I just want to make it clear that it doesn't affect any of the rest of the world, but I will view it through an American lens from overseas, which is that 297 million people in America use Google. 57 million people voted for Donald Trump to be the president. And so you have a platform now that has a louder voice to the tune of nearly 5-1 than the White House. That is bound to make people that want to control the message to the electorate nervous. And so there are reasons why you might want to curtail some of the excesses of these companies now, because they're truly massive and powerful. And one of the things that doesn't get reported enough on, and really has become a focus for me, is that if you look at the largest tech companies in the world, so I'll give you the list. So Apple earns most of its money outside America, not in it. Okay? Microsoft earns more money outside America than in it. Meta earns more money outside America than in it. Okay? Amazon earns more money outside America than in it. The only tech company that earns more money in America than outside America is Google, until mid-November last year, when it now earns more money outside America than in it. And so you've got the 5 most powerful companies with the largest market capitalizations in the world, with the fastest growth in the world, now making more money outside America than in it, and all of them many, many, many size larger than the politics of America. I think for people that control the White House and maybe have an influence on the law, that's something that might be causing some jitters at night.
Yeah, that's very well put, Ricky. And but I still think that still gets me back to the control issue. It's really about large, companies in control.
It is. And so let's talk about, so Section 230 has had a really good run if you're on the tech side of the aisle. Great news for you. But we are now seeing politicians from both sides of politics wanting to see a repeal. So we should talk about where we may be headed here. So I just wanted to, you saw the JD Vance thing, right? So JD Vance was on the hustings prior to the election talking about wanting to repeal 230. Very eager. He specifically called it out, said, I'm going to do something about this.
There are a couple things we need to do. The first, and pretty simple, is that we just need to repeal Section 230 for any company of over a certain size. Absolutely. Now, the reason I say of a certain size is because the big tech companies have an army of lawyers, okay? An army of lawyers, and they're going to go after every small company. They're going to use that army of lawyers, that army of regulators, and they're going to destroy the new entrants. So President Trump's new Truth Social or Getter or any of the alternative platforms that we're using, we need to reform it in a way that protects them, to protect new entries into this market while destroying the stranglehold and the power of big tech. That's what we got to do.
So there's clearly energy there for change. But to your point, this is about changing the political narrative, changing the ability to make your political opinions known, correct?
It is, yeah. And the thing about Vance is Vance and President Trump really are, if you want to change Section 230, they're probably your best bet at this point. Because President Trump had talked about doing this in Trump v1, and it seems like it's a matter of time before President Trump gets around to pressuring Congress to either repeal Section 230 or to have another narrowing of Section 230 to address his grievance around conservative viewpoints. I tend to be skeptical that that the FTC or the FCC, although the chairs of both those have been complaining about Section 230 and have been claiming that they're going to do something about that. I would just say, number one, the FCC really lacks the statutory authority to really impact Section 230. And if anything, the Dobbs decision by the Supreme Court, which overturned Roe v. Wade, and then the overturning of what they call the Chevron deference, really typifies the headwinds pushing against any regulatory agency in the U.S. that goes an inch beyond its congressionally mandated authority. In the case of the FCC, if you read the congressional notes as they were putting together Section 230, they were very clear that they didn't want the FCC to have anything to do with it. So it's hard to see. I know that we're in an era where I don't want to say the rule of law is over in the U.S., but it's certainly teetering. Anything is possible, but it doesn't seem like it's going to come from the FTC or the FCC.
Yeah, so what's interesting is that, as a journo, I want to kind of balance whether I'm happy for Section 230 to go for any motivation whatsoever and then to deal with the chaos after it, or whether to keep it as it is today and try and work around it. But, I'm not sure how I feel about that.
Well, and there is a little bit of a precedent. There was, a few years ago, FOSTA and SESTA, which were laws that Congress ultimately passed, designed to narrow Section 230's liability shield. And they were originally designed to address child sex trafficking. And of course, no politician ever is going to say, they want anybody to think they're soft on child sex trafficking. The problem is that it eventually expanded into prostitution more broadly. And one of the challenges of that is that prostitution is technically legal in a number of places, including some places in the US, but also the way the law was written, it technically implicated people who were trying to put out content in order to keep sex workers safe. And so, there is definitely an unintended consequences component to just about anything. And this is a pretty narrow set of amendments.
Yeah, so you would hope that, with all of the legal infrastructure we have and all the biggest brains in the world focused on this, we'd be able to, as a species, be able to figure out how to organize that. But where it gets a little bit more scary is when it's not about us as a species and when it's about AI. So, leaping forward, we are in the era of AI and we haven't really fixed the kind of last generation of digital while we're heading into a new one headlong. I was very interested. I know I shared it with you, Alan, but I was really interested in the comments of the former Google CEO, Eric Schmidt. He gave an interview where he is probably one of the strongest free speech advocates in the world. In fact, I actually think that a lot of people in big tech, in those other companies we've talked about, actually use the things that Schmidt said over the years as their justification for their position. Eric said it, therefore it must be right. But even he is saying that Section 230 cannot be allowed to apply in the era of AI.
They confuse free speech of an individual versus free speech for a computer. I am strongly in favor of free speech for every human. I am not in favor of free speech for computers. And the algorithms are not necessarily optimizing the best thing for humanity. So as a general point, specifically, we're going to have some conversations about at what age are things appropriate. And we're also going to have to change some of the laws, for example, Section 230, to allow for liability in the worst possible cases. So when someone is harmed from this technology, we need to have a solution to prevent further harm. Every new invention has created harm. Think about cars, right? So cars used to hit everything and they were very unsafe. Now cars are really quite safe, certainly by comparison to anything in history. So the history of these inventions is that you allow for the greatness and you police the guardrails. You put limits on what they can do. And it's an appropriate debate, but it's one that we have to have now for this technology. I'm particularly concerned about the issue that you mentioned earlier about the effect on human psyche. Dr. Kissinger, who studied Kant, was very concerned, and we write in the book at some length, about what happens when your worldview is taken over by a computer as opposed to your friends, right? Isolated, the computer is feeding you stuff. It's not optimized around human values, good or bad. God knows what it's trying to do. It's trying to make money or something. That's not a good answer.
So when a generative AI creates a statement or a novel piece of content based on what it's learned, and then it's published, that shouldn't be protected under 230, in his opinion. And I was really surprised to hear him say that, because that really kind of goes against everything that he said previously. And so, look, I don't know, what are your thoughts on that? Because AI just, if we haven't fixed the problem in the past, it's a bit like, I haven't sellotaped up my shoe before I start the marathon. This is going to end badly, right?
Yeah. So I this is where I get off the Section 230 train. I think that the large LLMs are using this and fair use as their get out of jail free card, in that with the latter, so they don't have to pay for any of the content, and with the former, so that they are not liable for the content. In my view, and I think my view is supported both by Congressman Cox and Senator Wyden, my view is that once you've taken someone else's information and effectively repurposed it into almost anything else, you are now that's something that you've lost that ultimate liability shield.
Yeah, let's go back to where we were at the beginning of this conversation. And I fully appreciate that I sound like a dinosaur when I talk about the newspaper industry, but newspapers are just a format of delivering the news. Okay. They are not, the news is the thing, not the newspaper. All right. So let's think about this in that context that you've just described. If somebody decides to write for my newspaper and I publish it, I'm liable as a newspaper, as a news brand, as a news organization. If I write it, I'm liable. If I task one of my reporters to write it and we publish it, I'm liable. I get fined or I go to jail. When I broke a story about 2.5 years ago about a patent that Google was about to release. And for the past decade, as you know, Alan, I've been running an AI company. And this patent that was leaked to me basically said that Google was going to get rid of Google search and replace it with an AI answer engine. Didn't even have a name back then. And this is what, of course, became AI Overviews. And so I immediately published the patent with some narrative around it. And my notes on it were that in the event of Google writing an answer that's unique using generative AI, Google is then a publisher and not a platform, and therefore shouldn't be shielded under Section 230. Now, when AI Overviews came out and started encouraging people to put rocks on pizza and various other bits and pieces, that's all. Yeah, that's a chuckle. But if it decides to say, "Hey, do you know what? You should not immunize your children," or you should, live really close to crumbling rock edges because the view's better, or, whatever stupid advice it made, and it actually causes real human harms. For the first time ever, Google's going to wake up to itself and realize that it's a publisher and it's no longer protected by the heat shield it's taken for granted. And that changes everything, because 230 just doesn't exist for them there. And the get out of jail free card they used to have is now a blacked out window truck taking them to jail, right? And I don't think that they've really quite figured out yet the implications of what that might be.
No, but just to be clear, that's how you and I and a lot of other people are hoping things shake out. As of right now, that is not 100% clear, and there are certainly policymakers who are taking a different view, saying that, okay, the information that goes into a large language model and the output is not, it still falls under the Section 230 protections. I think that's, to borrow a friend's term, a little bonkers, but it's not like that's a complete minority view at this point.
Yeah, but the beautiful thing about law and experience is that once bitten, twice shy. And we're 25, 30 years on from 35 years on from, the original concept of Section 230, and the world has moved on, and so has experiences. So my hope is that lawmakers will understand some of the nuances that we couldn't have seen or, imagined in 96.
Oh, hopefully, but it's important to note that the people who were the driving force in Congress for Section 230 do happen to support our view.
Well, that's helpful. So I want to close out today with some disturbing stories about where 230 has not worked in the best interests of people. Okay. And so I'm a strong believer and a strong advocate. And Alan, we talk about this all the time on this pod, which is that I just think that tech's not worth having if it doesn't help people. And I think profit is a wonderful thing, but I also think people are important. And I think that we need to work out that sometimes mission is as important as money. And you can go on about this again and again and again. But otherwise, why are we in it? And the reason I went into journalism was not for the money. I can guarantee you that. It was to have an impact on, society and hopefully helping the small guy do better. Really, that's what I was about. And so the reason I've spent so many years, this will be my third decade of following 230 and the implications of 230, is because I see it used sometimes as a blanket protection for things that are kind of inexcusable, in my opinion. And I think that if you want to change something as complicated as a law, you really need to build a groundswell of public opinion that understands that the logic just isn't the reality of what's actually happening on the street. So I need to share some real examples of where 230 has been used, not for what it was intended, but with really heartbreaking consequences. So the first one, I'll give you these are real examples. So in 2015, ISIS recruited some people on Facebook to commit a terrorist act, a shooting in San Bernardino, California. And the shooters killed 14 people, and they planned the entire event on Facebook. And when the families of the victims sued Meta by saying that they provided material support to the terrorists by allowing them to spread extremist content and recruit collaborators, the court threw it out on the first day using Section 230 because Meta claimed it gave them immunity. And those families had no recourse whatsoever. Okay? 230 was never intended to protect terrorist recruiters or the platform that enabled them. And then you raised the point earlier on about the case that Craigslist, its erotic services section, began to be used for human trafficking and underage sex exploitation. Again, the families and the laws and some politicians argued that they shouldn't be allowed to do that. Section 230, again, threw that out straight away. You mentioned the one Backpage that was facilitating sex trafficking. It did lead to some of the changes in Section 230. So we have started to see some of the bricks being chipped away at this, okay? And so we are starting to see a change. But there's a case that's just recently happened, okay? And this is difficult and painful, so I apologize, but it is sometimes important to talk about the difficult things. You're a parent, I'm a parent, but we should just put this one on the record because this might be the one that probably has more change for 230 than anything else. So in December 2021, a 10-year-old girl in Chester, Pennsylvania called Nyla Anderson was on TikTok when it recommended to her a game called the Blackout Challenge, which you've probably heard of. And it recommended to this 10-year-old girl that she should choke herself until she lost consciousness. Okay. And TikTok's algorithm had picked up on the viral traction of this game and was amplifying it and sent it to this 10-year-old girl. And Nyla's mother found her daughter unresponsive. And after 5 days in intensive care, Nyla died. 5 months later, the family sued, saying that the algorithm that TikTok had used to recommend this daily content to their child and send it to her was illegal, and that something should be done about that. TikTok's lawyers did use that big tech playbook. They immediately said, we're not responsible for this. Section 230 protects us from this. We shouldn't be held responsible. And the court threw it out. But Nyla's family didn't want to give up there. They kept on fighting. And so they took it to appeal and fought and fought and fought. And in August last year, so not very long ago, 5-6 months ago, the Court of Appeal overturned the ruling and said that TikTok couldn't use Section 230 when it came to its algorithm making recommendations. Now, that has significant implications for all of the tech platforms because they all use algorithms to amplify and accentuate and decide and target their content. And what was interesting was that in the court's ruling, and I'll just read this real quickly, it said, TikTok makes choices about the content recommended and promoted to specific users, and by doing so is engaged in first-party speech. Now, that really shakes Section 230. So what we've got is we've got the White House is interested in change. We've got some of the original creators of 230 interested in some level of change. You've got courts now backing up change, okay? And we have a very different shaped internet. Are we going to get some change here, Alan? Are you confident that this, you have a sense, do you think there's enough momentum to start to change something here?
I think yes. And I, on some level, I probably misspoke earlier when I said that the most likely path is, President Trump getting around to it and pushing Congress to change or amend Section 230, because I think the courts are certainly another venue. The challenge, though, is that, at least with this decision, and I'm just speaking as a lawyer and not as a parent here, but it does break precedent, and it arguably misreads what Section 230 is. Now, you might say, well, Alan, look, we've got to break a couple of eggs here in order to have a good thing happen. I understand that perspective. But for one thing, the judge took a position that Section 230 only applies to hosting of content and not to any other aspect of the publication process. And that's just not how the 30 years of precedent have operated. The judges also help that because online services get First Amendment protection for speaking third-party content via its algorithms, they say that it automatically must accept all liability for publishing that content. And I will just say that argument is directly contrary to the argument that Cox and Wyden are making. They're telling us that the intent of Section 230 was the First Amendment to work in conjunction with Section 230, not to have Section 230 only kick in when the First Amendment doesn't apply.
Yeah. So 2 last things on this. Something has to change if we want the future to be different. Okay, so somebody has to be overruled somewhere for any kind of change to happen. That's the first thing. The second thing is that the whole concept of First Amendment free speech and these issues are all uniquely American. But when a law like fair use, we've talked about that, and a law like Section 230 happen, they have no legal jurisdiction whatsoever in other countries around the world, but all countries adopt them as it's part of a worldwide web. Okay? And so there are, I can tell you, rumblings in Europe, rumblings in Canada, rumblings certainly over here in Asia Pacific, that says that maybe we just don't have those laws here. Maybe we don't respect those laws here. Maybe we might say to a tech platform that you can't hide behind fair use here. Actually, sorry, that's too provocative. You can't use Section 230 here. Okay. And when that happens, if that happens, then we're going to end up with effectively a broken web. We're going to end up with a splinter net with different rules in different territories, which isn't, again, what was dreamed of at the dawn of the internet. And so either the founding fathers got it half right, or the founding fathers of the internet got it half right, or the early laws got it half right. I suspect everybody's got it half right. But the world constantly evolves, which means we need to have evolving laws and evolving situations. And there's no really bigger revolution in the last 30 years than the arrival of AI. So Perhaps this is the moment. Or am I just being ridiculously optimistic, Alan? I just hope we can build a better future.
So I understand the frustration because the rest of the world is sort of stuck to a certain extent, or has been, with the American mindset and the American view. But I think that it might be helpful to talk a little bit about the First Amendment analysis because I think some of the underlying issues, even if you might reject the First Amendment, obviously say it doesn't apply somewhere else. Okay, fair enough. But a good deal of the problematic speech is actually protected by the First Amendment. Full stop. A lot of the speech that we would like to see not on these platforms is protected under the First Amendment. Now, our Congress is going to have a heck of a time trying to take down constitutionally protected speech. You say, okay, well, that's your problem, America. Fair. But even a good faith moderation enforcement, all that is enforced by a government, doesn't have to be the US government, it could be Australia. But even that gives that government the authority to define hate speech. And that's, at best, that's a little thorny. And so, the question is whether the government really can insert itself over the content moderation decisions of a social media platform. And I think, here where they landed is that the editorial discretion that is inherent in the content moderation is protected by the First Amendment. Now, your mileage may vary somewhere else, but I don't know how other countries get away from the good faith, how do we allow our government to define hate speech issue.
Yeah. So this is a beautiful way to bring it full circle back to the beginning. For 100 years, we've had a free press. And the free press has not policed itself. It has been policed by defamation, and it's been policed by contempt, and it's been policed by a whole slew of other laws. And sometimes the free press has been good, and sometimes the free press has been wrong, and sometimes the free press has behaved badly. Okay. But on the occasions when it's been wrong and it's behaved badly, it's been censured and it's been brought back into line. But we've still been able to maintain a professional and relatively high level discourse to the masses about politics and rights and all kinds of information. And people can choose whether or not to read it or pay for it or do whatever they want to do. And that's worked for 100 years. What we've had is 25 years that only works for tech companies. And we've now reached a point that doesn't work. So perhaps the past was a better model than the one we've got. Fair
enough. Although I might challenge the notion that it only worked for tech companies. And maybe I'm quibbling here because I would say it mostly worked for tech companies. But I do think that, if you're going to have a discussion about some of the horrible outcomes that are effectively facilitated via Section 230, there are some good things. We touched on them a little bit in the beginning. I mean, the enabling of a diversity of voices. There's a whole bunch of stuff out there that may not be my cup of tea, and I'm not even saying prurient stuff. My older brother loves Dungeons and Dragons, and he's got friends, all over the world where he does some variant of that. There are governments that will shut down that type of thing because they wrongly believe it's some kind of weird religious thing. And so, there's a diversity of voices that's facilitated by this. You've got things like online reviews, which, we use Airbnb, we use Yelp occasionally. We take a look at restaurants and say, well, how are those rated? Those things are, and what you don't want is the restaurant suing Alan because he didn't like the soup. That's just not a really good outcome. The advertising, even on publishers, the fact that is able to happen without people necessarily getting sued. If you restrict that and you say that that's not subject to Section 230 protection, you've now increased the bureaucracy and the cost of that. And I'm not saying that maybe it's worth it, but those are hard costs. There's some other things, but I just wanted to at least get your reaction to the, is there a throwing the baby out with the bathwater component here? And if so, what's your thinking?
I have to be confident that there are enough smart people in the world to make smart decisions around difficult topics. So I'm not saying this is easy. The whole point of the law is that we learn and we change the law and we adapt the law for the situations. And we've done that for 3,000 years, right? We can figure this out. I genuinely think we can figure this out. I just think that what we've got doesn't work. It's not fit for purpose for right now. And so all we need to do is to start a very real conversation about creating what it needs to be for the future. And where I'm most worried is that if you don't fix the situation of today, then you're a step behind for the future. And AI is happening right now. So this has to be decided, because right now the internet is the default communication channel of all of connected humanity. And that's likely to increase, not decrease. So the problem that we have today is about to exacerbate 1,000-fold. So we need to fix it, and time is short.
That's a great point.
All right. Well, should we get on to it then? I'm not doing anything till Thursday. Let's figure it out.
Let's do it. Bring out the whiteboard.
All right. Alan, great to see you. We'll be back again next week. We'll pick up on another topic. Thanks so much for joining us. And Alan, I will see you soon.
Take care, Ricky.
Thanks for tuning in. The Future Media Podcast is a production of Future Media and Ricky Sutton.